Good evening, everyone. My Lord Justice Dubash, Mr. Parikh, Mr. Behl, Ms. Sachdeva, and Mr. Hariani, our President, Mr. Thakkar, ladies and gentlemen. It gives me immense pleasure to welcome you all to our panel discussion, which is being held by the MCIA in partnership with the BBA. The speakers who are going to be talking today, the panel is going to be moderated by Mr. Hariani. And really speaking, everyone who is here really needs no introduction. As we all know, Justice Dubash was as a counsel and a very active arbitrator, active in arbitration, both as an arbitrator as well as a counsel, and now has taken the plunge to the other side of the room as well. Mr. Parikh is really speaking one of the finest arbitrators and arbitration practitioners that we have. Ms. Sachdeva is dedicated into promoting ADR. And Mikhail also is a dear friend of mine who now virtually, as he in fact told me today, exclusively practices as an arbitrator. And Mr. Hariani is a frequent face around courts who also needs no introduction. So may I first, before I just call upon our President to say a few opening words, if I could just request our President to give a memento of thanks to first to Justice Dubash. And memento to Mr. Parikh as well. And to Ms. Sachdeva. And to Mr. Mikhail Behl. And to Mr. Hariani. So with all these pleasantries over and done with, may I request Mr. Thakkar, our President, to say a few opening remarks.
Mr. Justice Dubash, Ketan bhai, Neeti, Mikhail, Anirudh, and friends. This is our first time in Bombay High Court premises, in BBA premises. We are having an event with MCIA. In past, we have done certain other events, but they were outside in the places, five-star hotels. We can't match your five-star hospitality, but this is Bombay Bar Association, so please don't mind that. Our association with MCIA has grown steadily over the years, built on a shared commitment to strengthening dispute resolution culture and enhancing the standards of professional practice. MCIA has been a vital catalyst in positioning Mumbai and India as a global arbitration hub, and BBA has always believed that bar must play a central role in that journey. Today's event is another step in that continuing partnership. The theme for today, the journey from counsel to arbitrator, is particularly relevant to our members. As arbitration expands and matures in India, many from the bar are increasingly called upon to take up arbitral appointments. The transition, however, requires not only experience as counsel, but also a deeper understanding of neutrality, case management, and the responsibilities that come with adjudication. Discussions like today's help equip our members for that evolution and encourage more of us to contribute to the arbitration ecosystem in a meaningful way. I would like to thank MCIA, leadership and team for their collaboration, and I thank all of you for taking the time to be here this evening. With that, I warmly welcome our speakers and invite everyone to engage fully in what promises to be an insightful session. Thank you very much.
Hello. Thank you, Nitin Bhai. Thank you, Naushad, for those wonderful words. Welcome, everyone, to this very interesting and relevant session. The topic is the journey from counsel to arbitrator. And it promises to be an interesting discussion because it affects a large number of members of the bar who wish to or who desire to ultimately act as arbitrator. Without further ado, let's get on with the panel discussion. The format will be this. For about 45 minutes, we'll have the panel discussion. Then we'll open it up to the floor. And if you guys have any questions, you all can place it to the panel. With that, let me start with the panel discussion. My first question is to Justice Dubash. Justice Dubash, during your time as a member of the bar, you were very active in arbitration. You were an active, not only a counsel, but an active arbitrator as well. And you were popular among litigants as well as law firms to appoint you as an arbitrator. How did you get your first appointment as an arbitrator, and how did you develop your practice as an arbitration counsel? And then finally, how did you ensure that people see you or litigants see you as a reliable arbitrator and thereafter get more and more appointments?
Yeah, hi. Thanks, Anirudh. First of all, before answering the question, I must tell you that I got a lot of phone calls when people got this notice saying that why am I on this side in a panel discussion which talks about lawyer to an arbitrator? As in, is there a mistake in the topic? Should it not be judge? To which then I had to explain to them to say that, look, this is something which I had conceived with Neeti and Nitin Bhai when I was the secretary, and just so happened that it could not take place, and I got elevated before actually it fructified. So with that, I had to then, I couldn't say no, and I had to take part in this, and so that's why I'm here. Now, to answer your question, actually, to be honest, I don't remember the first time that I was appointed as an arbitrator, or as in the date or the year in which I was appointed as an arbitrator. But I do remember this, that maybe I was about 10 years into the practice, and I got a call from a judge who asked me that, will you be confident enough to take up a matter as an arbitration, because I had been appearing in court in arbitration-related matters. So he said, as in, would you like to take up the matter as an arbitrator? To which I was taken aback, because at that point in time, not many counsel or not many juniors were appointed. And I said, yes, of course, why not? So that's how I started with my first brief, so as to say, as an arbitrator. And from there, I've never looked back. To answer your follow-up questions, what is it that you do to ensure that you get further briefs, etc.? Honestly, if you ask me, nothing. I have not done anything, because I've never believed in going out there and advertising yourself. Not that it's allowed, but not to market yourself or not to advertise yourself. I've just been doing what I normally do, which is appearing in matters, and the rest speaks for itself. As an arbitrator, one of the most important things that I believe people see, and when I say people, I mean lawyers, that is the attorneys on the two sides, and the counsels, because at the end of the day, they are your audience. They look for a fair adjudication. So the most important thing that matters to them is that they want a fair adjudication. As long as you can provide them a fair adjudication to their dispute in a timely manner, I think there's no reason as to why other people should not appoint you as an arbitrator. So if you keep these 2 or 3 things in mind, there's no, there are people who are rude, etc. Each of them has their own style of practice. But as long as you keep these fundamental things in mind, I don't think that anybody would be deprived of an opportunity of being an arbitrator.
Thank you. But just a follow-up question. Was it intentional that you were in the arbitration space, or like you mentioned, it was just a natural consequence and it wasn't something that you focused on or enjoyed particularly, just happened naturally?
So the fact that I was doing arbitrations was a choice. However, my first matter was not, as in I didn't pitch for it. I was asked and I said yes. And during the course of that matter, I realized that this is something which is interesting and this is something which I like to do. Not immediately, but over a period of time. Because when in several discussions that I had with several of my other colleagues, some people are just not comfortable deciding a matter. You may be a very good counsel, but it takes a different skill set to be a good arbitrator. You don't necessarily need to be a good counsel to be a good arbitrator. I'm not suggesting that good arbitrators are not good counsel, but you don't necessarily need to be a good counsel, because the skill set that you require as an arbitrator is completely different from the skill set that you need and require to be a good counsel. And patience is another point which is very important when you're an arbitrator. I also realize that now that I'm on this side of the bench, but patience is something that is also very important as an arbitrator.
Thank you, Justice Dubash. My next question is to Ketan Bhai. Ketan Bhai, you built an arbitration practice over the last several decades. I believe you've been practicing for around 4 decades, and you've been in the arbitration space since almost 2.5, 3 decades. So you built this practice when it wasn't very common for counsel to only specialize in arbitration. Also, you were appointed or designated a senior advocate, mainly or primarily based on your arbitration practice and not face time in court as such. So how did you get into the arbitration space, and how did you develop the credibility to be an arbitration counsel over the period of these last 25 years?
It was not planned. I was practicing in the High Court for many, many years. And as you rightly told me before we started this session, in 1990s, arbitration was not very popular, or not were there many arbitrations. But some arbitration matters came my way, and a couple of them were really big and took up a lot of time. And I was happy to take them. I enjoyed trials. Slowly the work increased, just nothing that I did about it, it's just that arbitration work increased, and there came a stage when I started defaulting in my appearances in the court because I was busy in arbitrations, and I thought it was unethical to tell the solicitor in the previous evening that I'm not there tomorrow, you manage the matter, and then you can't continuously do it. So I had to take a decision. And one fine day I returned all my High Court briefs in one go and decided that this is it. I am not going to go to court. Around 2002, 2003. I wasn't sure whether it was a right decision at that time. I had a lot of a period when I was in doubt about what I was doing, but I stuck to it, and the work increased so much so that there is no time to now come to court. So that is how it happened.
All right, thank you. Neeti, my next question is to you. Prior to your role as an arbitration administrator, because you are the Registrar and the Secretary General of the MCIA, you worked with several firms, including ELP, Trilegal, and I believe you worked in Paris as well. What made you shift to focus on the arbitration space and to grow and establish arbitration in Mumbai and in India after practicing as a practitioner for all those years? And I believe you started, you were part of the founding team of the MCIA in 2014-15, I believe.
Before I answer your question, Anirudh, firstly, I must thank Nitin Bhai, Justice Dubash, and then at that time a part of the BVA, that we could conceptualize all of this and finally see it to fruition. But it wouldn't have happened without Anirudh, who's also a part of my young MCIA. So thank you, Anirudh, for finally taking this forward and doing it. And we are very glad, and we hope that this is just first of the very many sessions that we plan to do it in the next coming years. So we look forward to your support. I wish I could just say this and repeat and say what Ketan Bhai said too, so that it was not planned. What was planned was definitely that in the 4th year of my law college, I decided I want to do arbitration. How? I do not know. I had no idea of how it's going to plan out. So arbitration just happened because I stick to it, and I did practice in Freshfields Paris office, which gave me an opportunity to work as a counsel. ELP, I remember I joined, I told Vikram Bhai, I said, listen, I'm only going to do arbitration. If that's okay, I'm going to join, otherwise not. So I had mentors like Naresh and Vikram who helped me. And then with Trilegal as well, something similar. Why MCIA happened is 2 reasons. I think one, when I was working in firms like this, you would always talk about arbitral institutions which are international. Nobody ever spoke about an Indian arbitral institution, and somewhere it's sort of always heard that why are you going to a Singapore, London, Paris to resolve your disputes? And it's the Indian lawyers traveling and resolving the Indian parties' disputes outside. So why couldn't we do something here? MCI just happened, and one of the individuals in the room actually pushed me on a corner in Supreme Court and said, MCI is being set up, move back to Mumbai, I was in Delhi, and join it, which is Vyapak. So all good, bad, ugly, whatever has happened with MCIA, I would say just pass it on to him and say that he hired the right person or not, I'm not too sure, but that was really, the push to say that, and it was also a feeling that how many times in your life you get to create something grounds up. So it was more as a challenge to get out of a cushiony salary of a law firm paying you to say, I'm going to join an institution with a complete white board and a canvas, and you could just paint it the way that you want to do it. So I think it was just like a challenge more than really a planned way of saying this, that now I've done the counsel practice, let me try and set up an institution.
Interesting. And it's great to have Vyapak Bhai here and other people as well in the audience. Mikhail, the next question is for you. So Mikhail, you've positioned yourself and you've, I think, consciously decided to take up mainly arbitrator and mediator roles, apart from, of course, your counsel practice. I believe you've published over 100 awards, correct me if I'm wrong. What made you decide to get into arbitration, and how did your arbitrator appointments first start?
So, I think like everyone else, there is a little bit of luck and good fortune that plays a role here. So you get your first appointment, I believe, when you've built up enough trust. So somebody has to trust you with this designation. Now, you may not know the reasons at the time, but you've probably done something before that to justify the appointment. Why I decided that this was for me is actually skill mapping. So I just felt that the pace of an arbitration suited my mentality and my personality better. I think I like the fact that you get to see something from its beginning, from its inception till its end. And I think we miss that a lot in litigation practice, where we are seeing things kind of compartmentally and incrementally, and we don't really see the whole thing play out in that sense. And I think arbitration offered that as an opportunity for me. I think I've skipped some of your questions.
No, so how did you get your first few appointments as an arbitrator?
So I think there is coincidence there, but I believe your peers would have to trust you with a nomination, and you have to do a good enough job in court for maybe a judge to believe that you are worthy. I think when Justice Dubash was speaking about his first appointment, I think what's not stated there is the fact that he had built up the trust. So I think that's the real signal that I want to give out, that you will build up that trust and then you will get your first opportunity. It's kind of a waterfall effect.
All right, thank you, Mikhail. Sorry, I'm going to go back to Neeti. I wanted to ask Neeti that, you know, the MCIA is one of the institutions which administers arbitration. As a person from that side of things, what are some of the qualities which would perhaps an MCI or an LCI, where you were the deputy registrar, look at when looking to appoint arbitrators, counsel as arbitrators? And what are some of the things that would, what are the qualities that you all would look for?
So Anirudh, I would say there are two C's really here. One is your competence and one is your credibility. The parties have to have a faith that the arbitrator that they have is a credible arbitrator. MCIA has been actually working in this space to have almost 50% or a little higher than that of our arbitrator appointments who are the first time arbitrator appointments. So there have been counsels who've practiced, who know how to appear in a matter, but have the credibility and a competence as well to take up that step and say that yes, we can adjudicate the dispute as well. So that's really, I would say, the two things. But the third point I would definitely add, when somebody is looking at making that transition, or I would say accepting an arbitrator appointment as well, that formal training definitely helps. Just as Dubash spoke about it, that you may be a great counsel, but that doesn't really make you somebody who can sit across the table and then adjudicate as well. I would add another layer to it and say that you may be a great counsel, you may be able to adjudicate as well, but the third skill set required is that can you actually draft an enforceable award? In MCI, we have a provision where we scrutinize the award, and I can tell you that some of the great counsels, that they know the law, and they would have done a great time drafting a brief, but when they're drafting an award, that's not how it has to be drafted, right? The parties' contentions, how you're deciding, what the reasons are, and finally why the conclusion has been reached is also a skill set. So I think people who have this sort of a training definitely something which an institution looks for when you're doing that your first arbitrator appointment. It's always difficult, right? People say you have done, like Mikhail has done 100, so getting the 101 is not difficult. But it's the first one which always is a difficult thing, and I think institutions can play definitely a role in that.
So next question is for Ketan bhai. I think just a follow-up on what Neeti said. You, of course, you haven't taken arbitrator appointments possibly in the last several years, probably because you are, of course, very busy as a counsel. But you've seen several arbitrators and arbitral tribunals over the years. And apart from, say, retired judges, you've also seen counsel act as arbitrators. What are the qualities which would qualify someone to be a good arbitrator, and what would the qualities be that disqualify them from being a good arbitrator? I think patience was touched upon by Justice Dubash, but anything else that you would add to that?
I guess, except for the extra skill set that Justice Dubash talked about. If you are a good lawyer, you will make a good arbitrator, because knowledge of law, um, reading the records, analyzing, appreciating the arguments, and the ability to decide what is right and what is wrong. I think all this is ingrained in you as a lawyer as well, except that you don't decide, you just take one side. But I mean, if you were to ask me not qualities, but what I would like to see in an arbitrator, I would like all our arbitrators to do a little more homework, uh, because it is frustrating to see them come and not be familiar with the record at all, and then you have to start from scratch. It would help a lot if they read and came, and matter would move so much faster, and it would be much more enjoyable to discuss points which arise rather than just make them familiar with what the facts are. So that is one thing one would really desire in the arbitrators. Second thing, I mean, again, instead of having so many sessions spread over months after the trial starts, once pleadings are over, evidence is over, and you start hearings, all our arbitrations have the habit of having sessions spread over so many months, and it prolongs the matter. And I don't blame only the arbitrators for that, even lawyers are guilty. But arbitrators can enforce and have the matter concluded in one or max 2 sessions. One session for evidence, one for arguments, in a matter of 2, 3, 4 weeks. If the matter can be concluded, that would be great, because it's for both sides' benefit. Even for a lawyer to revisit the matter after a gap of 2, 3 months, he also has to read through the whole thing again. So an arbitrator obviously also as much forgets the matter. So it's all wasted effort. If I've argued the matter 3 months back and we reassemble after 3 months, neither side is going to remember anything. So that entire argument has no meaning. So these are the things I would like to see in an arbitrator. Other than that,
So the next question I'm going to ask is to Mikhail, and then I'll get Justice Dubash to also comment on the same, because he may have a contra point of view. Mikhail, you are empaneled on several panels of institutions, LCIA, MCIA, SIAC, HKIAC. How did you approach getting empaneled, and does getting empaneled really help with arbitral appointments, or is it just something that builds your CV?
So the empanelment process is actually fairly rigorous, and I feel like I'm speaking on behalf of Neeti a bit, but I apologize for that. So institutions are actually performing a very important function when they create a panel. They are reducing search cost. So when you have a panel at the ready, what you have is data for people who are going to end up being users of an arbitration facility to identify a suitable arbitrator who has already been vetted through a process that is very rigorous. They usually have very objective categories of sort of benchmarks that you have to clear, which would be fellow grade, certain number of awards published, certain categories of cases covered, and an identified speciality of cases that you have taken up in the past and are willing to take up for that institution. So I think it plays a very important function both for the institution, because I think, again, I'm speaking on behalf of an institution and I apologize for that, but the request for arbitration is always urgent. So they've got to appoint an arbitrator in cases of default, or parties want emergency relief in very short notice. So it reduces search costs, and that is a very, very important aspect of arbitration. As far as the arbitrator who gets impaneled is concerned, again, it's functioning in exactly the same way. It's reducing search cost in having people choose you. So you have met an objective criteria and you have demonstrated your your desirability or suitability for being impaneled. So it's sort of a signal to the world at large that you are someone who should be considered. So I think it does play two very vital roles there.
Justice Dubash, do you want to add anything to this conversation, since you mentioned at the beginning that really it was organic for you, and I don't know if you were empaneled with any of these institutions.
No, I wasn't. I was always envious of people who were. But looking at the number of things and qualifications and tests or whatever that were required, I didn't apply to any of them because it would be a time-consuming process. And for whatever reason, I didn't go down because by the time this caught on, I had a fairly decent practice, both as an arbitrator and in the arbitration field and in court. And I didn't really think that I should, may not be right or may not, didn't really think that I should spend that extra number of hours and get the qualification done. But listening to what Mikhail says, I totally agree with what he says. And because of late, what I've noticed happening, and not when I say off late is not after going to the bench, I'm saying even when I was at the bar, I've realized that a lot of people who are taking up arbitrations as arbitrator are doing it, I don't know, maybe as a hobby or maybe just because they've been appointed and they can't say no, as a result of which they are not giving arbitration the importance that it otherwise requires. So what happens because of that? What happens because of that is in terms of dates. There are arbitrators who say that, all right, I cannot have a hearing between 11 and 5. So it has to be a hearing post 5 o'clock. And post 5 o'clock, you can only have one hearing unless you have people, etc., who work in 2 shifts post 5 o'clock. But as a result of which you lose out on a lot of time. Because post 5 o'clock effectively means that you can only have 1 2-hour session a day. And most counsel who also practice as arbitrators have a decent amount of work and require a decent amount of preparation for the work in court. As a result of which, what happens is the next day doesn't come immediately, comes after a period of time. As a result of that, arbitration unfortunately suffers. And that is something which I would like changed for the development of arbitrations in our country, or at least in our city.
Thank you for that perspective. Again, Mikhail, I'm going to ask you another question on how you have positioned yourself as an arbitrator. You are quite active in publishing articles, in having speaking engagements. You are active on LinkedIn on topics of thought leadership on arbitration. Do you think that today visibility plays a big role in arbitral appointments, and if you are positioning yourself as an arbitrator, that is a big factor in arbitral appointments, or is it something that you just do as a hobby or out of interest?
It's definitely an interest. I do like writing. I do like the whole intellectual process of creating something. But it does function in 2 ways. It is expressing to the world at large, I think, my ability to analyze an issue. So if that's the role of the arbitrator, as Neeti said, is to produce work at the end, which is written work, which is a sound expression of reasoning, then I think it functions also in expressing your ability to reason. So I believe publications and communications are important for that purpose. For me, I think I use social media mostly for communicating. It's not marketing as you would imagine it. I think it allows me to communicate and build collaborations with peers who I would not know otherwise. So I think another thing that people probably don't know is we generate 1 lakh graduates every year. So you have an ever-growing body of lawyers who you're perhaps never going to meet on a day-to-day basis. And I think you're missing out on something if you're not trying to build a collaboration there. So that's the whole idea behind everything.
Thank you. So, Ketan bhai, you of course started your practice in an era when there wasn't this kind of social media, there wasn't so many speaking, I don't know if there were that many speaking engagements. It wasn't common for counsel to publish articles, etc. Do you think it is a move in the correct direction, or it's something which, I mean, your reputation should be built on good old word of mouth and not on something which you are, I mean, is it a good move that is happening? Because it's happening regardless. So, it's an interesting point.
Exactly. I mean, it is happening anyway. So what I say makes no difference, actually. You're right. That's the way it was when I started, and but I wouldn't therefore say that that is the only right thing to do. Times change, the modes of communications change, the way we practice changes. So I don't do it even today, but because I probably come from those days and I'm happy where I am. But surely the newer generation should follow Mikhail and not me.
All right. So, Justice Dubash, this is a question which only you can answer on this panel. How has your experience as an arbitrator helped in the transition to being a judge?
Let me tell you the first thing that people told me when I was elevated is, was it tiring sitting for 3 hours at a stretch? How was your back? As in, did you feel restless? And to which I just turned around and said, okay, that was like every other day, because that is exactly what I was doing for the last 10 or 15 years before I was elevated. Either arguing in arbitrations or practicing as an arbitrator. And I would normally have a session longer than 2 hours. And if anybody over here would have appeared before Justice Vajivdar, for example, he has 4-hour sessions. So sitting for a long period of time is something which just came naturally to me. So that is something which, as in I thought I had an edge over my peers who were elevated. The second thing is, once you're an arbitrator, you already know, or you are accustomed to listening to two sides before making up your mind. Normally, as lawyers, you read the papers and you immediately have an impression. You don't think to consider that there is another side to the story. Because as a lawyer, not many people put themselves in the shoes of their opponent and actually think as to what the opponent will argue. So as a lawyer, you've grown for so many years only looking at a matter from one point of view. When you do a sufficient number of arbitrations as an arbitrator, you are accustomed to the fact that even though when you read something and you form an opinion, that opinion may not necessarily be correct. And on the basis of what the other side argues, that your opinion changes. In fact, it should change. So that is something also which I thought helped me, or is helping me even now when I'm sitting on the bench, because sometimes when you read papers in the night and you come the next day, the arguments that are put forth actually change the view that you had thought the previous night. So those are things that have in fact helped me during this transition at the bench.
Neeti, the next question is for you. Let's talk about diversity. And I'm not asking you this question because you're the only woman on the panel, but I am also asking you because of that. Have you seen a trend? I mean, as we all know, women arbitrators are underrepresented globally. Have you seen a trend of more representation of women over the last few years as arbitrators or even as arbitration counsel? And what can be done to bridge the gap? Because no doubt there is a big gap as of now.
I'm happy to represent the half of the women, the women folk in here and talk about it. I totally agree with you. It's not an Indian phenomena. It's a global phenomena. We have an organization called Pledge, which was started off in Paris itself, which was to promote women in the field of arbitration. But I think where the conversation gets difficult is that should you appoint an arbitrator who is a woman because you want to fill up a diversity issue, or you need to still look into the competency, right? So I think as an institution, you're very careful because, of course, we want to promote diversity. And I can tell you, year on year, we have published our statistics. MCIA has always appointed 40% plus of our appointments have been arbitrator who have been women. But we're also very careful that the arbitrator appointment is not only to a women to fill this diversity, right? You still need to have that competency. And I know I may disagree with few people on this panel to say that I think in India, the word marketability of yourself is taken in a very negative connotation. And I like the word that you used, that's why, which is to say visibility. And my question always is this, that if I do not know today that you exist, then how am I going to appoint you as an arbitrator? So getting out there and telling people that what your competence is. Nobody is going to appoint you because your name is an XYZ. Ultimately, people will appoint you on your competence. But that you are a competent lawyer, you are a competent arbitrator, needs to get out as well somehow. I totally agree with Ketan that we are not in probably that era, and it was a word of mouth. But today, a LinkedIn is nothing but a word of mouth. And let's be honest, I mean, Mikhail sitting here, and he probably can comment on it, that people do posts, and they do all sort of posts. When we see a post, we know that it is a chat GPT. We see a post, we know that it is copy-pasted from somewhere. We know it's a post to say that I have won a legal award, and it's a post to say that I was speaking at a panel like this. This is not the post we are talking about. We do find posts where people have done a critical analysis of a legal judgment, of an arbitral award, and those do get picked up, not in India, globally. We've had people who have been appointed by institutions like CIAC, HKIC, LCIA to say that, oh, we saw a post, an article, a peer-reviewed article being done by a person, and that was very intelligible way, right? I mean, if I look around the room, and I'm sorry that probably I may not recognize everybody here, not because I don't want to, but I don't probably come to the Bombay Bar as much, and I would want to. But if I look around in this room itself, I can tell you people who can be great arbitrator, but would never talk about it, like Shreni, Apurva, Vyapak, they do accept, but how many of them would know in the circles of appointment that they exist? So visibility is important, and for women, it's doubly important. Because I think as a woman, I can speak about it. It is not easy to be on a panel and speak. I probably would have spoken on 200 plus panels, but even today when I have to speak, my hands do shiver. I do sweat a bit, and which is very natural, right, to do. So as a woman, you still have to be out there and talk about it and say, this is what my credentials are, this is what I feel that I can get an arbitrator appointment, and trust me, institutions are always looking to get a larger pool of arbitrators. Sorry, I'll just add one more thing, Anirudh, I know I've gone on for long, is that training helps, and I will reiterate it. Again, I will refer back to Vyapak, who probably would talk about it a bit more. We have an institution called CIARB, Chartered Institute of Arbitrators, a 100-year-old institution which trains arbitrators. We brought them to come down to India and do the courses. Right? MCIA then partnered with them and said that we will conduct the courses, tell us how it is to be done, what needs to be done. And those are extensive courses. We've had retired judges across the globe take up those courses because they teach you the nuances of how you will conduct an arbitration, how you will write an award. And the pass percentage is pretty low, I must say. It's not that you just enroll into a course and you will just get it, the degree out of it. But once you have it, it's a gold standard to say that, yes, this person is credible enough. So I'm not saying that to become an arbitrator, please go to CIAB and do a course and you will get an arbitrator appointment. But having degrees, certifications, and trainings of this sort definitely helps you to get your arbitrator appointment. Second, what Mikhail was also involved in is, it's tribunal secretary courses. This was done in Hong Kong, the only institution which did it in Asia. Now we know that Thailand does it. Mikhail taught on that. MCIA every year does a tribunal secretary program, which is basically a transition, exactly what we have on the panel discussion. You have been a counsel, how do you get to be an arbitrator? You take this via medium of being a tribunal secretary, assist an arbitral tribunals and tribunal secretary, and then get your arbitrator appointments. We know of people like Chian Bao, other international arbitrators who have served as a tribunal secretary for years and now are one of the sought after arbitrators. So I think these are some of the things. One thing may work for one and the other may work for the other. But yes, as an institution, we're trying to promote diversity. My case management team is entirely women. I think Madhukeshwar is the only male that we have in the office. So I think sometimes he feels that we need to have more diversity on the other side. But yeah, we're doing our best.
Thank you, Neeti. Ketan bhai, there's been a trend in arbitration, domestic and internationally, of having a focus on written advocacy and written submissions. Would you say that how important are written submissions? Of course, this is not pertaining to arbitrators specifically, but to arbitration in general. But how important is written advocacy, written submissions, and what are some of the other trends that we are seeing in arbitration, both domestically and perhaps internationally, including with technology, AI, etc.?
I firmly believe that written submissions are the most important part of your case. Oral submissions play a limited role. If you're talking of foreign arbitrations, oral submissions are very limited, time is very limited, and you only highlight your points. Everything otherwise is read. So there they are anyway emphasize written submissions. Over here it is not so. We give a lot of time to oral submissions, but I believe, and for the reason that I mentioned in my earlier answer also, that it has limited value, because you argue today and the arbitrator sits down to write an award 4 months hence. He's not going to remember what you argued except what he has noted down or what you have submitted in writing to him. So he goes by his notes or what you have given in writing. And what you give in writing is a more logical way of presenting it. His notes will be sketchy, very limited, because he's just noting down what you are saying. It may not exactly reflect what you are trying to convey. So, to my mind, written submissions are the most important thing. Of course, you have to, at least in India, present detailed oral arguments. But the way I do it is I present my written submissions in advance. And I make my oral submissions based on those written submissions. Often people do it the other way around. First it is orally argued and later the submissions are filed. I file the submissions first. So that is the most important thing according to me. Talking of trends, we don't see a lot of things changing fast in Indian arbitrations. It's a slow evolving process and varies from arbitrator to arbitrator. There are some who adopt the newer methods faster, but a lot of them still are rooted in the old, or sometimes court ways of doing things. But one technical change we should seriously import and consider is live transcription, because that will expedite the speed at which the arbitrations go multiple times. And it needs a discipline, of course, on both sides. The arbitrator as well as the lawyers have to be very disciplined once live transcription happens, because there is no loose talk, there is no side remarks, everything is formalized and recorded. But it expedites the speed a great deal, and that's very good.
Justice Dubash, I think you touched upon this when you spoke earlier, but do you think it is a good idea now to specialize in arbitration? Are specialists the need of the hour, or should one keep their options open by also doing arbitration, also doing litigation, and kind of keeping one foot in each door?
See, that's a difficult question, but if I were to give you an honest answer, I would say that maybe for the initial years of your practice, you have to do everything. But at some point in time, if you realize that arbitration is where you want to be, you should be true to yourself and decide that if you want to do good in the arbitration field, whether you would be in a position to do that whilst also taking up court work. If you answer that yes, then you can do both. But if you think that no, you will not be doing justice to arbitration by appearing in court from 11 to 5, then the answer is that slowly, like Ketan, you may not give up all your briefs at one time. That's a very bold thing to do. But over a period of time, you could possibly reduce your court work and gradually shift. And at some point in time, you will find that 80-90% of your practice is now in the arbitration field. And that's the way, according to me, it should be. Because later on, after you've established yourself and after you're known that, okay, he's somebody to go to in the arbitration field, you should be able to devote the time that is required in the arbitration field.
Sorry, does anyone else on the panel want to add to this point? All right, so we are coming to the end of the panel discussion part of it. One or two last questions, and maybe we'll go around the room and see if there are any questions you all have for the panelists. Mikhail.
I just had something which I just thought. There are a lot of lawyers, a lot of counsel who say no to arbitrations. Why? Because they have consciously realized that they don't, or they're not going to be able to spend the time that is required in an arbitration. So similarly, I'd like to see more people in the arbitration field saying no to litigation, because that's the time that is required for you to actually grow and develop the arbitration field. Correct, that's right.
Add to that, and that's why probably what is being conceived as the Arbitration Bar of India, and we also have Mayuri here who's a part of it as well. The idea is that we need to at some point in time develop the specialists who would do purely arbitration and would not look at it as a sister concern and say that, I do the court work and then I do arbitration in the evening. And I agree with Justice Dubash that hopefully we will see a time when people will say, I'll only do arbitration and I'm not appearing in the courts anymore.
Great. Mikhail, what would your advice be to anyone who wants to what would your parting advice be to anyone who wants to be a arbitrator? And at a young age, you've got several appointments. So how would they, if you had to give them one piece of advice, what would it be?
So I would definitely advise you to publish literature. Because like Neeti said, there is a market for finding this information. It is a communication that is very relevant. It keeps you honest, and it keeps you it's very easy to get lost in the mundane. And I think analytical writing it's also fueling that curiosity that initially got you into this field as well. So it functions in two ways there. I think you must never allow your integrity to be compromised in any way, because if trust is lost in you, you're not relevant as an arbitrator, perhaps not even relevant as a practitioner. So don't let your your principles get clouded by any factor. So I think these are the two things that I would definitely suggest. And you have to upskill. You have to invest in learning. I spend 25% of my time in upskilling. So I will do about 3 courses a year, irrespective of what my schedule is like. I have to fit that in because I have this fear that I'm going to be irrelevant all the time. So I think that is another thing that I definitely believe people should do. And I don't think enough of our bar invest in their future. And that's the 3 things that I would suggest.
Justice Dubash, any parting comments or advice?
My advice would be everybody should take up at least one matter as an arbitrator. If you have the opportunity, if the opportunity presents itself to you, please don't say no unless you know and you've actually been there and you don't like it. Don't be afraid to say yes to being an arbitrator because it's not really difficult. The job of an arbitrator, of course, besides the administrative work, conducting proceedings, etc., is on the basis of the material that is presented to you by applying law, which most lawyers we know or we're supposed to know, you're supposed to give a verdict. So you don't have to go and do all the research yourself. There are counsels who will appear before you who will do that. And then you can do your own independent research if you so wish or if you feel the need to do it. All you need to then do is decide as to who's right and who's wrong.
Thank you, Justice Dubash. Ketan bhai, do you have any advice or closing remarks?
I told you not to ask me this question.
That's the advice. Don't ask. You told not to ask.
No, not really. But I just want to emphasize one thing, that arbitrations are basically full trials, which you don't really see them happening in court as much, at least. And trials need hard work. You need to really spend time on the matter, read through the entire record, however long it takes. Full preparation is what is the key to success, and if you do well in one matter, work attracts work. So work hard is what I would say to succeed.
Thank you, Ketan bhai. Neeti will let you have the last word.
Thank you very much. I think my biggest problem is that I have these fresh graduates 2 years into the profession and saying, can I get my arbitrator appointment? How can I get my arbitrator appointment? I think today to become an arbitrator has become a fashion. It's not. Like Justice Dubash said, it is a difficult job. You have to adjudicate, and please remember, under the Arbitration Act, an award can only be set aside on procedural irregularities and not on the merits. So it's not that you have to get on the bandwagon and put it again on the social media that within the first 5 years of my professional life, I have accepted 10 arbitrator appointments. I don't think it goes down well in the legal profession per se. You need to have the maturity to understand what the law is. You need to have a maturity to understand how to decide on one side or the other and to give the reasoning for that. So, as Ketan bhai said, do trial work. Arbitration is not an appellate work, it's trial work. Do trials, go to lower courts, get your hands dirty, do a cross-examination, and then think of becoming an arbitrator. I don't have a magic number, how many years in the profession, but yes, at least feel confident enough that you're resolving a dispute which may not, an award may not get set aside on the bad merits as well as decided.
Thank you so much, Neeti. Now we'll have a brief question and answer session. If you have any questions, please raise your hand and someone will come to give you the mic. Keep your question brief and please introduce yourself and also say who it is addressed to. Yeah. Sorry, can some...
Good evening, everyone. My name is Kavita Mohanty. Absolute pleasure to be here. Just with background, I did my LLM at Cambridge and I did my English barrister training in London and I've returned home. The reason I want to ask this question is you see a growing trend of people moving abroad to Geneva, London, Singapore, and then they love the atmosphere at Queen Emmanuel, Freshfields, etc. And these are your young graduates who are then consumed for whatever reasons into the system over there. Maybe the better weather or the pay, but it becomes then difficult for you to get back home and then re-establish yourself. And my Lord Justice Dubash mentioned that specialism in international arbitration is a good thing, and we're at 22, 23, I'm 27 though, but we're trying to specialize so early on, and we want to stay abroad. Is there any way we can increase the marketability of Bombay, Delhi, so that you study and you realize you want to go back home, not just because of your parents, but because of the opportunities? Thank you.
Your question is for?
Everyone. Whoever is competent to answer it.
It's just because it's an MCIA BBA event, the difficult questions come here. Oh, God. I mean, I can firsthand tell you this. I did my LLM. I started to work in Freshfields Paris office, and it was a very good life. And then you start questioning yourself, why am I here? What am I doing? Bad weather. It's not good weather. What sort of a practice are you doing? And it's a great learning curve for sure. And if you get an opportunity, why not do it? But I think there's a definitely growing market in India. You look at how many people who have moved back are doing pure arbitration practice. And like I said, that is the reason, right? Whatever jurisdictions you have named, if you look at the practice here, there's a clear-cut distinction between arbitration and a court practice. And this will not even be a question that the person who's doing arbitration would be appearing in the courts as well. It's not heard of. So I think we are sort of, with the Arbitration Bar of India, with institutions like MCIA, we are sort of seeing that shift. Is it as at nascent stage? Absolutely. Will we reach there sometime? That's the hope. But it's a vision that I think people have envisioned and are working towards it. But it is still sometime far off for that, I would say.
So I think actually there's this hesitancy amongst people to be the first mover. And I think that's the threshold that needs to be broken here. So it's okay to be the first person and to not be a great success. And I think that's something that I would advise for you.
Yeah, go ahead.
Okay, my name is Parikshit Kumar. My question is to both Justice Dubash and Ms. Sachdeva. So, Ms. Sachdeva talked about that there need to be a tendency to read before coming if you are an arbitrator, and that is a change that needs to be there. My question is, we all have our personal biases in mind. Like when we read something, we picturize that scenario in our mind as per our personal idea of that particular topic which we are reading. So as she has mentioned that it is important to read, is it gonna be prejudicial when you read and frame your own bias and then you listen to both the sides? So probably you may have thought or understood the matter in a certain light, and maybe that light is siding with a particular side, and in that way how can you be fair? The point Justice Dubash have mentioned that in this profession the core ideal is to be fair, and he didn't elaborate on that. I also want him to particularly elaborate on how to be fair and what exactly is being fair, because fair is also a subjective term. Anything can be fair. According to me, something can be fair, but according to the rest of the world, that may not be fair. So how do we evaluate ourselves that we are actually being fair, and that is also seen to be fair to both the sides? Because if that is important, then we have to also ensure that.
Thank you.
Okay.
Justice Dubash, it's a very complicated question, so.
Okay. See, I'll try and answer it to the best of my ability as to what I understood your question to be. Like I mentioned earlier, it's only human that if you read a brief, you pick a side. There are times when you read a brief and you just can't pick a side. That's also possible. But when you have the power to decide, that power has to be exercised properly. And when you are sitting in that seat, you have to have that much of confidence in yourself that no matter what you perceived the matter last night when you read it, when you're sitting on the dais or when you're hearing a party in an arbitration, at that point in time, your mind will be open to listening to that person and then either ratifying the decision that you took last night, or you have to be open to change. You can't sit over there and say that, all right, no, as in I'm not going to hear or change my mind. As long as you're open to the fact that your first impression is wrong, you'll be a good judge. In terms of deciding what is fair, I don't think anybody in this room or can give you an answer to that question. But the way that I put it, if you decide something and you are happy with yourself and that decision, then you are fair. That's the simplest way that I would put it.
I had a question, may I?
It was a question to Neeti as well, so if you want to add anything.
I mean, you subscribed this comment to me and I'll happily take it, but I think it was Ketan Bhai who said this, that he would expect an arbitrator to read and come. I think, no, that's fine, and I would expect the same, I would say, so it's not very different, but I think what he said and probably what I would try and, I think that what he meant was also this, that what we expect the least from an arbitrator is that please read the documents which have been filed before you. That today we find a problem that we go into an arbitration as a counsel and the arbitrator has just had no clue of all the pleadings which have been filed in the matter. So I think it was more on that and not to take a side by just reading one side or the other side's brief. Have I understood that?
No, absolutely. But I will trespass. You have not asked me, but I will still answer. Your question was that if the arbitrator or a judge, whoever, he reads in advance and forms a view, then isn't it against fairness? If he comes unread, his mind will be an open, like completely blank paper, and there will not be no prejudged notions in his mind. That's your question. Say a judge comes without reading. He will first hear one side. Should he listen to him? Because if he listens to one side, he will start forming ideas without having listened to the other side. He will still be unfair. If your concept of fairness is that you shouldn't have notions, in fact, the argument of one side will only concentrate on what are the positive points for him, right? He will not highlight the negative points, which the other side will. So while I listen to him, with a blank mind, I come to the court, I listen to him, I will probably be convinced by what he says because I have not yet heard him. But when the other side starts arguing, I have to keep myself open to his arguments. So whether I come having read or I don't read and come, it's the same thing. I don't think by reading in advance you are kind of affecting the fairness at all. The advantage of having read and come is that then I can come and before this side starts arguing and showing me page 1 and page 2 and goes up to page 100, I can say that I've read all the pages. I have a problem with these matters in your case. Now please address me on these points where I am not happy with what your case is, so that he can address me only on where I have doubts. And that expedites and shortens the procedure. Instead of he taking me through for 3 hours, he takes me through the record before he starts arguments. That is the advantage.
Sorry, is it just quickly, because we have other questions also.
But we also do one thing, that when we read something, we connect all the dots as per our best judgment. So in a way, our judgment may not be in the center. It may be on this side or on the other side. So my question is, when a arbitration is going between two fair sides, I mean, both of them are having equally strong point, and it is very critical and difficult point to judge. In that point, since you have applied your mind, so you would always think about your side and side with that side more. In that light, how do you actually be in the center and not aside from here to there?
They've already...
You have to keep yourself open. When you read also, when you hear one side also, till the end, You have, your mind has to be open.
I think the panelists have answered the question. It's more of a comment. We'll have one or two last questions. I think Apurva had a question.
Good evening, I'm Advocate Apurva Mehta. I'm a partner with A&B Legal. And my question is that there is no formal segregation as such in India in the roles between lawyers and arbitrators, in the sense that an arbitrator can be a counsel in a matter and in another matter he could act as an arbitrator. So is there some rationale behind having a demarcation in the sense that once you become an arbitrator, then you do not, or you consciously choose only to act as arbitrator and then do not take up counsel briefs? Because I believe in mature jurisdictions, like I think in some jurisdictions like London, they do not, arbitrators then do not act as counsels. Is there some rationale behind that, or is that something that is chosen by arbitrators in their practice, is what I wanted to know, to any of the panelists.
I think it's just a matter of choice, I would say, Apurva, because I know a lot of practitioners as well who would do both the thing. So I think there are two sorts of distinction. One is that you're doing an arbitration practice, either as a counsel or as an arbitrator, or you're going to do a court practice. That distinction is very clear internationally when you look at it, right? You don't have people doing both. But I think when you talk about within the arbitration circle itself, somebody going on to just taking an arbitrator brief and not representing a counsel, I think it's just a very personal choice. You pick up people who have been law firm partners, have been representing clients over a period of time, and then are not able to take arbitrator brief because of the conflicts. And you know that conflicts in arbitration you have to be very, very careful about it. So when they feel that they're not able to take enough arbitrator appointment because of this conflict, they take a step back and say, we will not represent clients anymore, I'm not a part of a law firm anymore, or a chambers anymore, and I will only do full-time arbitrator practice. So that could, I think, the conflicts could just be one of the rationals, or just what you prefer and you feel that you're better at it would be, but I don't really think it's any legal logic to why one would do one or the other.
I just have one comment. We have an example on this panel of a person who does only practices as a practitioner, and then of course Mikhail is primarily, of course he does do counsel briefs, but he's primarily acting as an arbitrator and mediator. So I think the shift is happening slowly, but like you said, there's no formal distinction out here, and abroad you do have that distinction. All right, any more questions? One last question, I think.
My name is Hitesh Soni and managing partner of Hitesh Soni and Associate. My question to Honorable Justice Dubash, that we see in a appeal many of the common ground which is challenged is the biasness of an arbitrator. And being an arbitrator, how difficult is to get into that psyche that although there is a disclosure, but that biasness, how an arbitrator deal with that challenge, that one of the common ground, one of the party would take that the arbitrator was a bias.
See, honestly, as an arbitrator, you don't do anything different when there is an allegation of bias made against you. Your behavior has to be your behavior. And if your behavior is as it should be, then there is no need for somebody to raise an allegation of bias against you. Because one thing that we find, it's a practice, is that no matter what you do, if there is a party who wants to raise an allegation, no matter what you do, an allegation will be raised. So you don't have to pay any attention to that. As long as you do your job, and like I say, you are able to sleep at night with what you are doing, then what you are doing is right.
All right, thank you so much. We've run out of time. That brings us to a... Sorry, go ahead. Last question.
Today's world, international artificial intelligence. So my question, all member panels, AI in international arbitration. So what is big deal?
Sorry, can you repeat that? What was the question?
Artificial intelligence in international arbitration. So what is the big deal today? Big deal, yeah. Yes.
Anyone?
What is a big deal? Yes. Because today's world, artificial intelligence. So
I think, it's a big change. I'll answer this question. And
I think one of the things under the artificial intelligence which people are testing is going to be predictive analysis, which is what they're talking about, that today can you feed in the data, feed in your facts to a chatbot or to an AI and say that, could you predict that on what side am I going to get a dispute? What are the percentage chances of a person ruling in favor or not in favor of me? I think that's the big question that people are talking about it. It's not about a big deal being made of it. I think artificial intelligence is sort of just trying to make the life a bit easier, but I don't think it is out there to take the life of any one of us here. We all have our own skill sets, which we should probably hone better and feel confident enough that we have more to contribute than for AI to take away from us. So it's not just a big deal about it.
Right. Thank you so much to the panel, and that brings us to a close. Thank you for the audience being, very interactive. Yeah, also there's tea and snacks, which is there after this. I just want to do a quick vote of thanks. When we came up with this concept, Nitin Bhai has been very, very hands-on, approachable, and so has Naushad. So thank you. To the entire panel, thank you for being here, for giving your valuable time. To the BBA, to the staff, and of course the standing committee members. Kainaz has been here, Firoz has been involved, and so has Swanand. Thank you all of you, and thank you to the audience, and please join us for tea and snacks.